So today for our Landlords Need to Know webinar series, I'm presenting the California Residential Lease Essentials. This is basically going to be a rundown of everything you need to include in your residential lease agreement. Now, put an asterisk on that because there's so much that you can include in your lease. There's always more that you may include. What I'm going to try to touch on is all of the things that are required by law and specific situations where you might consider adding something else important. So this arises from the fact that after interviewing some of our nearest and dearest clients who have been with us for a long time, I learned that one of their biggest fears is the fear of government regulation, governments reaching into their businesses, their properties, and changing their rights or changing the rights of tenants. And it's no wonder that those are our most popular webinars. When we do new laws webinars, we always get really good attendance. This webinar is also getting a pretty good response, and I think it's because the lease terms that you provide, what you use in your lease is very much directed by the law and what you're required to do in the law. And also many of the things that we put in our leases are responsive to the law. So at So Cal Realty Law, we provide leases that are current and fully compliant with the law. I prefer not to sell a lease form to a client. I prefer to have a client come in, do a consultation with our team members, make sure we understand the situation and that we provide the most current and updated lease. If I provide a form, it is almost definitely going to be outdated within a year. So by the time that tenancy is over, that form is going to be outdated, and I wouldn't want someone using an outdated lease that came from me. So if you come in and ask for a form, yes, we have forms, but we will always recommend that you allow us to provide you with the most current form and to not reuse that form later on. And just to note, although many of the things that we're discussing today apply to all types of leases, we are focusing on residential leases today. When it comes to commercial leases and mobile home leases and short-term vacation rental leases and all sorts of other kinds of leases, there are many, many other things to consider. And we do handle commercial leases, but today we're going to focus on residential. So to start out with, what is a tenancy? A tenancy is a consensual agreement for the occupancy of specific premises. But it is important that an express formal rental agreement should be used. Now, is a formal rental agreement required? No, it is not. You don't have to have a written agreement in order to have a tenancy or to be a landlord. And a tenant may become a tenant at will or a periodic tenant simply by taking occupancy of the premises. And that is an occupancy that's created by the landlord's implied consent to lease the premises. In particular, the tenancy arises, whether it's intended or not, if the landlord accepts a periodic payment for occupancy of the premises. So in those circumstances where the tenancy arises by the implied consent, it is governed by a lot of statutes that exist and regulations that exist, regardless of whether anything is placed in writing. The lease is used to confirm the terms of the tenancy and make sure that the parties have the same expectations. So when we use the term lease versus the term rental agreement, a lease is typically referring to a fixed term. So that's a fixed term, maybe 6 months or a year. A rental agreement could be anything. And honestly, the term lease could be used interchangeably with rental agreement at any time. But typically when you're talking about a lease, you're talking about a fixed term. So there are a number of things that are basic requirements of residential leases. And this is when we're drafting a written lease, the basic things that we should include as a minimum. And this does not include California statutory compliance requirements. These are just things that, as a matter of due course, a lease should include. So it should state the parties that are responsible for the lease. These are the landlord and the individual or individuals who are responsible for making the lease payments. It needs to describe the premises. Sometimes, so with residential leases, you'll usually see the address of the property, maybe a unit number. With commercial leases, you'll typically see the address, the unit number, and the square footage. There can be limitations in a lease. For instance, if it's a lease with a roommate where the owner is occupying the premises, it might state certain rooms which the tenant has exclusive occupancy of, and other rooms where there is a community use. So it's important to describe the premises. Even if you only have this much space in your lease agreement, it's still important to make sure that you've done an adequate job of explaining it. And if it needs to be continued onto an addendum, that should be done if necessary. The duration of the lease is important. So a verbal lease for a term of less than 1 year is fully enforceable. The term of the lease, it's not just because it's a verbal lease, that doesn't mean that it's a month-to-month lease. You can agree to up to 1 year lease term verbally. We like to put those in writing because if there's a dispute as to whether the tenant should be allowed to leave, if you've got nothing in writing and it's your word versus theirs, that becomes a harder dispute to settle. Leases that are for more than 1 year must be in writing in order to be enforceable. Your lease should always include the rent, the amount of rent, who it's paid to, and how it's intended to be paid, where it needs to be delivered. Those are required by statute, those terms. If you intend to charge late charges, it needs to be in writing. If you have a written lease, you should always note what the security deposit is, the amount of the security deposit. Take note that the law is changing as of July 1 with regard to how much you can charge for security deposits. Look back at our past webinars over the last couple months and you'll hear all about that new law. A lease should always provide the terms of payment for utilities and other utility type charges, expenses of the property, who's going to pay them, how they should be paid, specifically gas, electric, and water. We often see trash and some various other utilities that might come up. In residential leases, those are the basic ones though: gas, electric, water, maybe trash. Occupants other than the parties, so the parties are the ones who are responsible for payment of the lease, but occupancy can be by a variety of other people, including family members, minor children, elderly family members. It's important that the parties agree on who are the occupants, who are the tenants, versus people who might come in as guests. We see a lot of disputes come through where people move in after the tenants have taken occupancy and they're not part of the lease, and then, you know, that can create some disputes. It's important to note the condition of the premises and give the tenant the right within a certain amount of time after taking occupancy to notify the landlord of the condition of the premises. Also, the lease should require the tenant to provide updates when the condition of the premises change, and put the obligation on the tenant to keep the landlord notified of the condition of the property. The use of the property, when we're talking about a residential lease, you know, isn't it obvious that the use of the property is as a residence? Well, that's not always obvious to the tenants. Sometimes tenants like to start a business and run it out of the garage or out of the office space within the premises. And that can be perfectly fine, but it can also cause some complications for the landlord, particularly if the type of business is disruptive or against HOA rules. I can give you any number of examples where the use of the property becomes a part of the dispute. So I like to put in a lease that the use is for a personal residence only. And then, of course, if the tenant wants to negotiate a different type of use, they can address that with the landlord. Terms regarding maintenance and repair of the premises, who is responsible for what type of maintenance, the yard. If there is an HOA taking care of certain plants and the tenant is not allowed to maintain the yard, you want to be clear about certain things like that. Most residential leases are pretty clear about that the tenant is not allowed to make any improvements, and before they do any major changes or construction or anything at the property, they should get permission. So maintenance and repair typically falls on the landlord, but it can be placed on the tenant. It's important for a lease to declare that all parties agree that they will comply with laws and regulations of the state of California, the city in which the property is located, the HOA rules and regulations. It's important to provide a copy of the HOA rules and regulations or any other rules and regulations that the property may be subject to. Make sure to provide those to the tenant and have them sign a receipt, or include in your lease that the tenant acknowledges that they have received the HOA rules and regulations. The termination of the lease is typically handled under the laws that exist, but if there are any adjustments to the way that a lease may be terminated under the law, sometimes that is possible with a residential lease, and so it's important to point those things out. Usually a termination provision identifies what constitutes a breach of the lease and when the parties may terminate the tenancy. Pets are another issue. When dealing with a pet, you know, there's a pet addendum can be used to identify the pets. But pets are not to be mistaken with emotional support animals and service animals. Emotional support animals and service animals are not pets. Under the law, they shall not be referred to as pets. That would be a violation of the law. And so you're not allowed to charge extra for an emotional support animal or a service animal. There are some things that you can do to address the type of animal that's being kept as a service animal or an emotional support animal. And, you know, there's a lot more that goes into navigating tenants, support animals and service animals if there are issues. But generally, landlords should be aware that they are not pets and they're not something that you put on a pet addendum, but it's okay to document that the tenant has an emotional support animal. In fact, I am in the habit of attaching the tenant's proof that they have an emotional support animal to the lease and identifying it as part of the lease as an attachment there too. So there are, as far as landlords entering the property, there's a statute that governs very specifically when a landlord may enter the property, giving 24 hours advance written notice. That statute can be amended by the lease. So there are certain things under the law that you cannot alter in a lease. They're not waivable. You have to abide by the way that it's written in the law. But there are other things like the landlord's right to enter that can be adjusted by the terms of the lease. And so in certain forms, it provides that the tenant, the landlord may be allowed to enter by the tenant if the landlord gives verbal notice. That the landlord may enter in the same day if they provide verbal notice to the tenant, or if the property is being listed for sale. As long as the tenant's been notified that the property is being listed, the lease provides that the landlord or their agent may enter to show the premises to potential buyers or potential new tenants. Most leases provide some reference to insurance. I explain on a regular basis to landlords that there are different types of insurance that relate to a tenancy. The obvious one is renter's insurance. You want to require your tenant to have renter's insurance, although it cannot always be required by the landlord. But the lease should recommend that a renter have renter's insurance. The lease should also recommend that the tenant have liability insurance. Liability insurance is different from renter's insurance because the liability insurance would need to cover the entire structural value of the premises. Most landlord insurance policies, homeowners insurance policies, as long as the landlord has notified their insurance company that they are renting out the property, most of those policies will cover damage that's caused by the tenant, such as if the tenant causes a fire or a flood. But it's important to check in because there are some that do not cover the tenant damage. And in those cases, if you can't get insurance that covers damage that's caused by the tenant, you need to require the tenant to cover that damage. Again, there are some exceptions that as far as it requiring insurance, particularly with affordable housing and Section 8, you can't require it. But I do like to have that in the lease. And then attorney's fees provisions, the problem that we see, so most leases have an attorney's fees provision that says if the landlord has to evict the tenant, or if there's any dispute arising from the lease, the prevailing party receives their attorney's fees. Many leases leave a blank in there so that the landlord can enter a limitation on how much attorney's fees may be awarded by the court. And in every case that I have had attorney's fees come up in litigation where my client had a limitation in their lease for how much they were allowed to be awarded, they have always gotten less than they should have, meaning that the limitation is almost always less than what they've actually spent on their attorney's fees. So I don't recommend limiting attorney's fees in your lease. You should not place any cap. The other side of that coin, as far as limiting attorney's fees in your lease, is that maybe your tenant sues you and the tenant wins. If a tenant sues the landlord and wins, then the tenant receives their attorney's fees. And so then it may be an advantage if the landlord has limited their attorney's fees to a low amount, because then it doesn't become a target or a goal for the tenant to get an award of a large sum of attorney's fees, or their attorney won't be as potentially influenced by the possibility of getting a large award of attorney's fees under the lease. So I understand both sides of the coin, but I think it's rare that an attorney is encouraged by an attorney's fees provision to litigate a case to trial. We could debate that, you know. I just want to put that out there, that those limitations on attorney's fees can be problematic, and I see them more problematic for my landlord clients than for advantageous, you know, to the landlord clients. Okay, so then closing formalities is just a broad term that represents certain boilerplate terms that attorneys like to put in contracts, or that anybody likes to put in contracts. So that would be something like, you know, this contract, this lease shall be governed by California law. The four corners of this document constitute the entire agreement between the parties, and there are no other agreements, verbal or otherwise, that were not contained in this agreement. It provides for the parties to accept electronic signatures and to be signed in counterparts, meaning that you might have two copies of the lease, one with your signature, one with the tenant's signature, and you can put them together. That's what counterparts means. And there's a bunch of other boilerplate type things that go into closing formalities. You want to make sure you get signatures on your contract. And then it's important that you provide a copy to the tenant in the language in which the lease was negotiated. So California law requires that landlords who negotiate with a residential tenant primarily in Spanish, Chinese, Tagalog, Vietnamese, or Korean must deliver to the tenant and any other person who will sign the contract or agreement prior to executing a lease, sublease, rental contract or agreement, or other term of tenancy contract or agreement for more than 1 month period, an unexecuted foreign language translation of the contract or agreement. What this means is typically you'll have an English version and then you'll provide a Spanish copy. It's important to have an English version in case you need to go into court and enforce it. But the copy that you give the tenant must be in the language that you primarily use when you communicate with the tenant. And it's limited to just those particular languages, although, I mean, err on the side of caution if you're using a language that wasn't listed, if it's not Spanish, Chinese, Tagalog, Vietnamese, or Korean, and you're capable of translating it into another language, you should do so. Okay. So here are some considerations for long-term residential leases, long-term as opposed to short-term vacation rentals. These are, regular leases. Do you want to go forward with a verbal agreement, or do you prefer to have a written agreement? So a written agreement is not required in order to create a tenancy. It's not required in order to enforce a tenancy that's less than 1 year. Written agreements are advantageous for many reasons, particularly their enforcement, because if you've got a verbal agreement and all of a sudden your tenant doesn't agree with the terms that you think you entered into, then you have very little proof of what you agreed to. Do you want a fixed term tenancy versus a month-to-month or non-fixed term tenancy? A fixed term is typically one that has in writing or verbally less than 1 year, but in writing, it's usually 6 months or a year. It can be verbal to have a fixed term, but the month-to-month tenancy can be terminated with 30 days notice versus the fixed term tenancy that has a specific term in which the landlord and tenant are obligated to maintain the relationship. So the fixed term reduces enforcement problems. In a tight rental market, when there is low vacancy, a fixed term may be a disadvantage to the landlord because it may limit them from raising the rent or finding a better, higher paying tenant if the rental values go up. It's good for both parties because the tenant is obligated to stay for the duration of the term. The tenant can't just vacate with 30 days notice. Likewise, the landlord cannot capriciously terminate the tenancy or raise the rent during the fixed term. For a tenant, it creates the assurance of stability for at least that term. In a tight market, tenants are at a disadvantage when they're negotiating. They have less leverage to negotiate with landlords when housing is difficult to come by. So tenants may prefer to negotiate the longest fixed term possible. This also locks in the amount of the rent that they're required to pay for that lease term. And a note, under rent control, so if it's a rent controlled tenancy or like a Section 8 type of tenancy where the amount of rent is somewhat controlled, the fixed term lease is not particularly advantageous to anyone. The landlord prefers to be able to increase the rent when the local board approves increases, and then the tenants are already protected by statute or ordinance, so they don't need the fixed term to maintain their occupancy. Their occupancy is already protected. How long should you give for a fixed term lease? I think from a landlord's perspective, you want to do less than a year for the initial lease term. It's like a free look, an opportunity to get to know the tenant before you are subject to many of the tenant protection laws. Consider the California tenant protection regulations that kick in after the tenant has been there for 12 months. That's when you're required to provide just cause to terminate the tenancy. But if you do your initial tenancy for 11 months, then if you're not getting along with the tenant, you're not yet subject to the requirement of just cause. So you can terminate the tenancy at 11 months. You give a 30-day notice, and you don't necessarily need to list the just cause. We still recommend it for other reasons, but it gives you an opportunity to get the tenant out before they become imbued with all of those lovely tenant protections that California provides them. Consider the City of San Diego ordinance. If your property is within the city, those tenant protections do not apply to 3-month leases. So I've puzzled over this many times. I don't know why why exactly the city created this, but if you do a 3-month lease term, then the city tenant protections don't kick in. You can do 3-month lease terms until you hit the point at which the California tenant protections would kick in, and then you can continue to do 3-month lease terms, but you become subject to other tenant protections after a while. And we talk with trustees and fiduciaries many times about what an appropriate lease term would be. How long should they try to keep tenants in the property? And it's many of the same considerations, but just be aware that trustees and fiduciaries may have additional considerations with regard to how long they want that tenancy to last. Okay, and then we have the consideration of whether you want to establish a tenancy versus provide a license. A license is something less than a tenancy. A license is where you have a guest, like a short-term renter or a visitor who is not intended to receive the rights of a full-fledged tenant. So in order to create the tenancy, the parties must show that they intend to establish the landlord-tenant relationship. They have to include a definite description of the rented property, specify the rent to be paid and at what intervals it's to be paid, and then state the specified term, or if you fail to specify the term, it's interpreted as a month-to-month lease. So with those things, you have a tenancy. A license is usually declared to be a license. You see licenses more often in commercial context, and it's harder to maintain a license with somebody who's living in a residential property, because California really does give them a lot of rights pretty quickly. If your lease is ambiguous, it is typically going to be construed against the landlord. The landlord is usually considered the drafter of the lease or the landlord's agent, and so he who drafts the lease, it's construed against them. All right, so considering utilities, some things that should be addressed in a written lease is whether the utilities are included with the rent or paid separately from the rent. When the utilities are included with the rent, that means the landlord is paying them. If they're paid separately, that typically means that the tenant is paying them. If you have a building that does not have separate meters for the different units, or you are renting to roommates so that they can't just see how much gas and electric they've been using, you need to put in your lease the statement that gas and electric is not separately metered, and explain how those bills are meant to be divided. So you would say that this tenant is going to pay 50% or 30% of the gas and electric bill. And then the tenant agrees to that, and that's great. You don't need to go measuring it. Whatever you've agreed to, that's what you can enforce. Now, there are certain subdivisions and buildings where the water service is provided through submeters that are charged separately. The landlord basically acts as the water company and provides the bills to the tenants. There's a bunch of regulations for these. HOAs oftentimes do this as well. So when the water service is provided by submeter and the landlord is providing the water service bills to the tenant. There are specific disclosures that are required by law prior to executing the lease, and that's very important to remember. You probably are aware of that if you have that situation, but if you're not sure, you can feel free to ask us and I'll send you the long list of disclosure requirements that are required in there. Okay, hazardous substances, mold and floods. We'll talk here about lead-based paint, mold, and flood, and then we'll talk about asbestos separately because it is different circumstances required for asbestos disclosures. So the lead-based paint disclosures are required whenever the property was built prior to 1978. The landlord must disclose any known lead-based paint, existing lead-based paint, or lead-based paint hazards, and that must be done before the tenant becomes obligated to pay any rent. If the landlord does not comply, there are heavy penalties for failing to notify the tenant. Civil or criminal fine up to $10,000 per violation, potentially imprisonment up to 1 year. The violator also faces treble damages liability to the lessee. That means 3 times the amount of their actual damages plus costs and attorney's fees and expert witness fees. And a lead-based paint claim would usually include a personal injury claim as well. So be very careful that if you have a property that was built before 1978, that you are making a disclosure. Even if you don't know of any actual lead-based paint or lead-based paint hazards, we typically want to disclose that the property was built before 1978 and may have lead-based paint. If you've gotten a lead-based paint clearance, then I think that is also advantageous to disclose it because then the tenant can feel more comfortable. So there's no reason not to disclose that you believe you've remediated the lead-based paint, but also disclose that the property was built prior to 1978, and I guess it could still have lead-based paint. There is a required mold disclosure consumer booklet that you can download from the California Department of Public Health. We've also sent it out as one of our free resources with the webinar on many occasions. It is required with all residential leases. You have to provide it. Also, the landlord must provide a written disclosure to prospective and current tenants if they know or have reasonable cause to believe that the mold in the property exceeds the permissive exposure limits or poses a health threat. How do you know what the permissible exposure limits are? You can go to the California Department of Public Health and they have all sorts of resources, not just this consumer booklet, which has that information in it, but also booklets on what to do if you think you have mold. So it's a great resource. They're easy to find if you just Google California Department of Public Health. I didn't put the website on here. And then for flood hazards, now we have to disclose those as well. How do you know if you've got a flood hazard at your property? There is a very useful website where you put in your address and it will show you whether you are subject to a flood hazard area. And the landlord must disclose that. What our typical disclosure says is either the landlord is not aware or the landlord is aware. You would be aware if you have to carry flood insurance. And then you can also provide this website to the tenant just to confirm whether they believe that there's a flood hazard for that property. Okay, so asbestos is something that for your typical lease, you're not required to disclose. Asbestos may be in any pre-1979 property. There's also a 1981 date. I think asbestos officially stopped being used. I forget what act was passed when, but 1979, prior to 1979, any commercial construction requires asbestos notices to the tenant. So that's for commercial and multifamily buildings only, and public buildings. So there are detailed written disclosures that must be made, and you can find those on the EPA and HUD websites. You can find them online and download them and attach them to your lease. And that, in my opinion, would be the best resource if you don't have another set of forms that you trust that are well updated. I've used this before and I'm not going to dwell on it, but there is a lease provision that under California law, the law states that, you know, if there's a natural hazard that completely damages the property, then you can terminate the tenancy. If it's not the tenant's fault and the premises are completely destroyed, you can get out of that lease. You are allowed to alter that law with your lease. And so the CAR form does a nice job of altering the law for the benefit of the landlord to state that if the premises are partially damaged, that the landlord can terminate the lease. So the difference is under California law, the premises have to be entirely damaged, like entirely wiped out in order to be released from the lease agreement. But you can put a provision in your lease that says if they're partially damaged, you can get out of your lease. Okay. Pest control and pest disclosures are oftentimes required. So a pest control company has to disclose to the tenants what they are using, what they are, hold on, let me give you the specific information that's required. Structural pest control companies are required to give a prescribed written notice to property owners and tenants. It must state and include the pest to be controlled, what type of bugs they're controlling or rodents or whatever, the pesticides that they are using and their active ingredients, and state the mandated warning that pesticides are toxic chemicals and that the frequency of treatment pursuant to any contract for a periodic service. So how often are they going to be treating? Where the landlord or an authorized agent is routinely applying pesticides in a common area or on a set schedule, whether it's with or without a licensed pest control operator, there is a prescribed written notice that must be provided at the outset of the service and to each new tenant when you get a new tenant into the property. Again, it has to state the pests to be controlled, the name and brand of the pesticide to be used, and the specific notice required by the state law, which is what I stated before, that the pesticides are toxic chemicals and frequency, and then also the frequency of the treatment. Then we have a bed bug disclosure, and I had to look this up because I could not recall when it arose. I remember when I first started hearing about bed bugs, and I guess it was around 2017. Not that they didn't exist before that, but there was legislation in 2017, and ever since January 1, 2018, we are required to provide a bed bug disclosure with our leases, and that's under California Civil Code 1954.603. There's specific language in that statute that you have to provide. Some of that is just information about what bed bugs look like, and if you've seen it, you know it's kind of a lengthy disclosure about bed bugs. Okay, other kinds of disclosures that are required. Ordinance locations, different from ordinance that we were talking about. Like ordinances are military ammunitions. You see that there's no I in the word ordinance. Anyway, if you live in Tierra Santa, you've seen this sign before. Tierra Santa, formerly Camp Elliott. It used to be a site where they trained military troops, and there was an accident back in the 80s that killed a couple of kids. And ever since then, this law has been in place that if you live in an area that's known to be the location of military ordinances, then you have to provide a disclosure not only to tenants, but also buyers. If you've ever received a notice from a local health officer stating that you have to do methamphetamine or fentanyl remediation, You have to disclose that to your tenant. Even if you've completed the remediation, you still have to continue to provide that disclosure to the tenant. And then for real estate professionals, if you're preparing a lease with a term of more than 1 year, you have to provide your agency disclosure under Civil Code 2079 and disclose who you are representing and disclosing what your fiduciary obligations are to the people that you represent. All right, so California residential leases that have options to purchase. This is a different animal altogether, and I just wanted to mention it because sometimes it's not treated with enough care when it's being done. Usually there is a real estate professional involved in the creation of a lease with an option to purchase. And I find that they often are unclear, ambiguous, and not appropriately containing the appropriate disclosures. So just be aware that if you're creating a lease with an option to purchase, you have to provide, as a real estate professional, your agency disclosure pursuant to Civil Code 2079, your agent's visual inspection disclosure, your client, the owner of the property, needs to provide a transfer disclosure statement. And by the way, if there is no real estate professional involved, the owner still has to provide a transfer disclosure statement and make appropriate disclosures at the time that the lease and option are entered into, not later, not when they exercise the option. This has to be done when the option is created. And then you also have to provide the natural hazard disclosure report, which we purchase from third-party companies. It's very easy. It doesn't cost very much. So if you're doing a lease with option to purchase, number one, use an attorney. Make sure you get an attorney involved. Make sure everything is very clear. When we do these, there are typically 3 documents involved. It's the lease, and then it's a separate option agreement that states separate consideration to be paid for the option. Sometimes the signature is the consideration, but and then we also do the residential purchase agreement in advance. You can leave certain terms of that purchase agreement open, but it's usually to both parties' advantage to make sure that the terms of the future purchase are settled at the same time that the lease terms are negotiated, the option terms are negotiated. The purchase agreement should also be negotiated. There can be some flexibility there. Again, it's highly recommended that you get an attorney involved with that. Okay. So then various lease forms. I want to save time for Q&A, and I guess I've been talking a lot because we're running out of time. But I use the California Association of Realtors forms. I have a broker's license, and I subscribe to the realtor forms and the realtor organization, and I really think that they do a lot more work updating these forms and keeping them current than I would ever be able to do. So they're great. I think that the California Apartment Association forms are also really great. The Southern California Rental Housing Association forms work well for me when I've had to review them. They seem to contain everything that's required. You want to make sure that you're getting local forms with those. Sometimes they don't update or provide local addenda. So there's a City of San Diego addendum that should be included now. I know the Southern California Rental Housing Association has that. I have my own that I prefer. Attorneys always have their own custom forms. We provide leases very often for our clients here at So Cal Realty Law. As I said, I typically default to the CAR forms, but I have a variety of my own forms that I have collected over the years from a variety of other transactions I've been a part of, both residential and commercial forms and addenda. So we've got lots of options for our clients, and we make sure that it's a fully current form. I do not recommend using LegalZoom, Rocket Lawyer, or other online forms. They're usually much shorter than the forms that we use. They usually don't have all of the compliance requirements for California. So there's lots of other things that we need to consider. Exempt versus non-exempt properties. California tenant protection laws have these exemptions and disclosures that need to be made in order to comply not only with California's Tenant Protection Act, that's the AB 1482, but also, City of San Diego has its own compliance and tenant protection guide that needs to be used. City of Chula Vista has some compliance documents. If you're in the city of Los Angeles, there's, some things that need to be addressed in your lease for the rent stabilization ordinance. And you need to register with rent stabilization program or with the city. And then we've got lots of other optional attachments, pet addenda, guarantees for people who are guaranteeing a lease, lockbox addendum if you ever intend to put a lockbox on the property. Realtors like to make sure we have our fair housing disclosure on our lease. Section 8 leases should always have the additional HUD addendum. I can't tell you how many times I've had clients, landlords come in and say they have a Section 8 tenant and they cannot provide me with a signed copy of the HUD addendum. We just download it and we apply it anyway in those cases, but it's important to have a signed copy of it. There's also some other notices if you have Section 8 that we use when we issue notices to tenants, which is the Violence Against Women Act notice and addendum. And I'm going to skip over the short-term rental considerations. That's probably a webinar for another time. But when you're dealing with a landlord or a landlord's tenant who wants to be able to get a short-term residential occupancy permit, there are some additional things that need to be drafted into the lease in order to be eligible for the permit. All right, so that's everything I've got for you today.